Well, I think we should take one more call.
Yep, it looks like we have another caller coming in just now. Hello, caller. You're on the air with Pony Radio.
Well, I don't understand what hearsay is. I hear a lot about hearsay. I mean, it's something about what someone said, but I don't know where or when or why I can't use it.
Well, first, before we talk about whether or not you should be able to give hearsay to the jury, whether you should be able to use it, we should talk about what the concept of hearsay means. It's a little bit like character because it's turned out to be surprisingly difficult to define very well. But in its foundations, in the place where it originally came from, just like character evidence originally came from not putting in people's past crimes to show they were guilty of this crime, hearsay evidence came from the notion that if you call a witness and put them on the witness stand, you should not ask them to testify about information that they heard another witness say. That is the origin of the term hearsay. And you should ask them only about what they saw and what they have direct knowledge of. That's what we want from a witness. Now, it turns out that when witnesses hear other people make statements, say words, sometimes the way that the person who calls the witness is asking the jury to think about that doesn't really depend on whether or not that person who's not there, that the witness is talking about, really meant what they said or really knew what they were talking about. Sometimes you're only putting it in front of the jury so the jury will know that it was actually said at that time. It might have been a shouted warning, watch out, and that may mean that the person who heard that warning should have paid attention, whether it was true or not. Should have been more careful, whether it was true or not. So that would be what would be called a non-hearsay use of exactly those words. So whether or not something's being offered for a hearsay use, words that somebody heard somebody say,
yes,
or whether it's being offered for a non-hearsay use, is a very, very troublesome question, just like the difference between character use and non-character use. And once again, you know who likes that? Lawyers. Yeah, because it means that lawyers who are very skillful can get an advantage in the way they conceive of and argue about exactly that. Once again, whether lawyers should be able to get an advantage from being skillful at arguing about such fine distinctions is a different question. But we're not going to go into that right now.
We're not going to go into that now because I think we are out of time. So I want to thank you very much for joining us today.
It's been my pleasure.
And it's a pleasure to meet you. I consider you an intellectual equal. So thank you very much.
Thank you. Coming from you, Pascal, I know that that's intended as the highest form of flattery.
Indeed. And we'll see you next time. Thank you very much.
Thank you.
Bye.